A recent filing in federal court claims that YouTuber BitBoy is the subject of an open FBI investigation for allegedly making death threats and other harassment that was directed against a group of attorneys that filed a class action lawsuit against him. Now, those attorneys have gone into federal court and have at first filed a notice to the court saying that they wanted to have a hearing about alleged harassment by BitBoy, and then very recently, a couple days ago, filed an updated version of that has outlined what they are claiming are death threats that were made against them, and a number of calls that they claim harassing them, and various other things that people were sending to them or saying to them in calls. I'm Kevin Nooper. I'm an attorney at Nooper and Covey, and I want to walk y'all through the basics of this class action lawsuit against BitBoy, which derives from his alleged promotion of FTX, the cryptocurrency exchange and set of companies that were run by Sam Bankman-Fried and that have now resulted in the indictment of Sam Bankman-Fried on a number of counts, including things like bribing Chinese government officials and various other, it looks like he's going to have a lot more criminal charges coming for him. But these attorneys claim that local police departments as well as the FBI are now investigating this death threat against them and that BitBoy was behind it, and they are asking the court to take action on it in this class action lawsuit. And so I want to walk y'all through first kind of what they were saying, what BitBoy was saying. He's claiming that he got very unhappy with the attorneys for filing what he says is a frivolous lawsuit. And actually, I'll tell you why I think probably it was frivolous when it was first filed, at least. And so we'll go through all the details and all the drama and all the receipts that the attorneys have provided, because they've given a lot of copies of what they say are the harassment and what does look like a death threat, although by who, we don't know. All right, this is a copy of the complaint that has gotten BitBoy very angry and unhappy with what the attorneys have done here. And he has, at a minimum on his public Twitter accounts, has for sure complained about it loudly and in sort of language that is very, not toned down is maybe the way to put it. Now, the one thing when we're talking through this, I actually will agree with BitBoy that at least this version of the complaint is frivolous, and it probably should not have been filed the way it is. And I thought this was mind-boggling when I looked at this as an attorney who does class actions. I was really amazed that this was filed the way it is, particularly because there's at least one very good law firm on it, and you're looking at it going, how in the world did this ever get filed this way? And let me show you just why. So this is the complaint, and the thing that stood out to me so much, and I actually could not really believe it. I thought there might be an error in my Adobe PDF when I was doing this, and I will do the exact same thing, which is a find for the name Armstrong in this complaint. It is 73 pages, so let's see how many times it references Armstrong. You can see here at the top, they include his name on the caption as a defendant. They have a single sentence in here that says, Defendant Ben Armstrong, a YouTube star with more than 1.5 million subscribers to his YouTube page, was paid to endorse FTX and is a citizen and resident of Atlanta, Georgia. So that is one sentence here in the 70 some odd pages. And then this goes to what's called the civil cover sheet, which is a thing that you file kind of explaining to the court clerks how to do things. And then no more matches for Armstrong. Well, let's look at BitBoy and see if we find something there in here. So now I'm searching for BitBoy. Nothing. So literally in this entire 73-page lawsuit, there is one sentence about Ben Armstrong, which is the real name of BitBoy. Now, as an attorney, that was a giant red flag. Like, what is even going on here that they're doing this? The complaint's actually well written, I think, in terms of just like writing and legal stuff, which makes it even worse almost on some degree. It's like, and to explain to you why, as an attorney, that was kind of mind-boggling, is there's something called Rule 9b, which is a rule that says that you have to, in cases of fraud, which is what these allegations are based on, you have to plead them with particularity. You're required as an attorney to go in and give specific allegations, and the allegations against this group of people in this lawsuit are that they're basically separate YouTube influencers. It's at a high level, they're separate YouTube influencers who were separately running YouTube channels and being paid to promo Sam Bankman-Fried's FTX, as well as FTT, which is kind of a token that he was selling, like basically a little cryptocurrency thing. You can't, as an attorney, just put one sentence in there and win your lawsuit. That is literally the definition of frivolous to do this, and it really probably is a serious problem for those attorneys doing something like this. I think that the reason they did this is probably to do this lawsuit as a placeholder, planning to amend it. One of the things you may not be aware of in terms of class action lawsuits, which are lawsuits where a couple people come in and be representatives of a large group of people who were injured similarly, there's often a race to the courthouse. So when something like the FTX thing happens, attorneys will sort of race to try to file because they know that other attorneys may file on the same thing they heard in the news, and only one or two of the firms at best can be appointed the representatives of that class. And so a lot of times you get 7 different lawsuits, they all get combined in one court. The court does consider who filed first, who did the most investigation. It's a little, looking at this, the date on this is and this is document 1, so you can see it's the first document of the lawsuit, is March 15th, 2023, but then the collapse of FTX was kind of last year, so it is strange even like, that was my theory about this as to why they just basically included zero details whatsoever about him. On the other hand, you're looking at it going, that's sort of 5 or 6 months out from when we knew about Sam Bankman-Fried, and this stuff has all kind of been out there for a while. So you're not really, if you're racing pretty slowly. So why in the world did the attorneys not include any details whatsoever about this person they're suing or what he's doing? There can be scenarios where the people are all running one company. Like, just to give you an example, like let's say BitBoy had a YouTube channel that was more along the lines of Mr. Beast, not to drag him into this because he's totally unrelated. The reason I reference him is because he has like a large production team. And so that kind of YouTube channel will have, it's run like a company. And so there's multiple people in it, but they might all be working together on the same representations or the same video. So if they were making false statements about FTX, or if they were all being paid to endorse it, you might kind of group them together and say this group of people did this. This complaint's talking about completely separate people. So you would have to plead at a minimum what each one of them did if they're totally unconnected and aren't part of a group. And and it's even at sort of like a fundamental level for this. I'm going to show you some of the claims here just to appreciate how crazy this is to see it like this. They have to plead. Pleading means just saying in your first complaint, alleging for some of these are false advertising type claims, and in those cases you have to show what the advertising is, what is the representation in this case on the YouTube channel, and there's really none of that as to BitBoy at all. So that concerns me, and I'll show you at least a couple of what are called the cause of actions that they raise in the complaint. Cause of action is a legal theory as to why you can recover if certain facts are true. I'm going to walk you through a little bit of the details of how this 9B rule works, just so you understand why BitBoy got mad. He probably didn't understand actually why he got mad in the first place, other than I got this lawsuit and didn't say anything. But legally, why it concerns me looking at this is that so you see the first cause of action that they have here is the Florida Securities and Investor Protection Act. And that's, they outline a little bit about in here what it is, that it's this act that makes it unlawful to sell a security within the state of Florida unless security has this exemption. And the liability includes agents of people who are the seller. So they're saying that these things that were being sold by the FTX entities, they were sold by FTX, but then they claim that the defendants, which would include BitBoy, are agents of the FTX entities. And then that's pretty much all they say, this few paragraphs, and that because the agents, which they say include BitBoy, were selling this unregistered security, that therefore they violated this Florida statute. Now, what is the problem? Why am I like, kind of, what are you doing here? What you're looking at right here is a legal case, which is a decision in a different case but it's from the same district. You can kind of see at the top here that it's from the Florida Southern District Court. That's where this was filed, Southern District of Florida. And you can see it's talking about the exact same act, the Florida Securities and Investor Protection Act. And the court here holds that that claim is subject to the particularity requirement of Rule 9B. What does that mean? The court will, so the court's saying it sounds in fraud. That means it's based in fraud, the allegations, and it has to be alleged with particularity. And this explains sort of what this Rule 9B is, which any attorney is going to know about this. It's a rule in the Federal Rules of Civil Procedure, which are the rules that govern how civil lawsuits work, not criminal lawsuits. So if two people are suing each other, then this rule applies. And it provides that it says in all averments of fraud or mistake, and an averment is just you're saying something, you're alleging a fraud, the circumstances constituting fraud or mistake shall be stated with particularity. Particularity means you go into the details of the who, what, where, when, why. And then this says Rule 9B is satisfied if a complaint, and that's the document we're looking at, sets forth 1, precisely what statements were made in what documents or oral representations or what omissions were made, the time and place of each such statement, and the person responsible for making, or in the case of omissions, not making same, and the content of such statements, and the manner in which they misled the plaintiff, and what the defendants obtained as a consequence of the fraud. And then this is something else that is actually in the circuit they chose. So circuit is like every group of federal courts is divided into or grouped in what's called a circuit. So the circuit is just like what states go up to a certain kind of appellate court that handles all those states. So if you lose, you go up to the Court of Appeals for that circuit. Florida is in the 11th Circuit. The 11th Circuit, and so each circuit has their own like law. It's usually they look to each other kind of for persuasion, but the only thing that's binding is what is in that particular circuit. And the 11th Circuit's kind of unique on this one particular question. They're actually very, very aggressive in terms of how they interpret 9B, in particularly in terms of when you group defendants together and talk about them like not specifically, but for themselves individually. And the 11th Circuit has the most aggressive version of this rule that I've ever seen for any circuit, and it says that Rule 9b does not allow a complaint to merely lump multiple defendants together, but requires plaintiffs to differentiate their allegations when suing more than one defendant and inform each defendant separately of the allegations surrounding his alleged participation in the fraud. And they say the reason for this is fair notice is the most basic consideration. So you have to notify the defendants of their purported role in the scheme. And in cases involving multiple defendants, the complaint must inform each defendant of his or her alleged role in the fraud. And so in other circuits, it wouldn't be this broad. Actually, it probably would be this broad for this version of what they're doing with BitBoy. In most other circuits, I think if they had like a situation where a YouTube channel or a company or something was being run by multiple people, you're allowed to group together people where the allegations are kind of the same because they're part of the same company. They're not like as strict in other circuits. The 11th Circuit is like way strict, but even here, like this really wouldn't survive kind of almost anywhere, or I think really anywhere, because what they're doing is not even saying anything at all about what BitBoy did. And in particular, what you notice is they don't say, there's nothing in this complaint about what BitBoy's YouTube channel said. What were the misrepresentations? What was he doing to promote these people? What was he paid? Who paid him? How? Like anything about that. It just says he was paid and he promoted this. Well, okay, what did he actually do? I can't tell from this complaint. We will be able to tell later, and I'll show you sort of some documents later that show what he did, but it's sort of after the fact, and the attorneys really should not have filed the complaint this way, I don't think. Now we get to their second cause of action, which is the Florida Deceptive and Unfair Trade Practices Act. So they're saying that BitBoy violated this law that's designed to protect consumers. And if you look at it, so again, it's not saying anything about him. We can't find nearly anything about him in this complaint. But it says the purpose is protecting the consuming public from unfair competition, unfair acts, deceptive acts. And it says that basically you look at what acts that they're alleging. They're saying that the defendants had materially misled consumers, and it doesn't really even say kind of what they did. Unfair deceptive practices described herein, but again, they didn't say anything about what BitBoy did throughout this whole complaint. They just sort of have general stuff about influencers kind of promoting crypto in about 70 pages of that. And they say that there was deceptive and false advertising. So it's very clear that this is based on some kind of false advertising, but what is it? As you know, there's nothing from BitBoy's channel here, nothing in here that says anything about what this is. Now, does this statute have to be pled with particularity? I'll just real quickly show you another case because this one's a little, I think the answer is probably, but there's a little bit of mush that kind of saves the attorney somewhat on this particular count. This is a federal court case. You can see it's from the Middle District of Florida, which is a different district. Generally, this opinion probably would be considered persuasive, but less likely to be followed in the Southern District. And you can see that the Middle District has consistently held that this type of statute, FDU, Florida Deceptive Unfair Practices Act, claims that hinge on allegations of misrepresentation, so that's what they just said, are grounded in fraud and are governed by 9b's heightened pleading requirements. But then it says federal district courts are split on the question. So there is, when they say a split, that means that federal district courts have disagreed on how specific you have to be on that particular law. So the second cause of action. There are some courts that would say, actually, you don't have to go into that much detail on this. I'm not sure they would even still survive that. I mean, there's 9b, which is like the high rule, but the high rule. But then you also kind of have to at least say something. But then there are cases from the Southern District of Florida, which is where this lawsuit is, and I'll show you one of those. This one, as you can see, is from the Florida Southern District. So that is the same court that this is in, which means the courts generally give those opinions a little more weight. Although there does look like there's kind of different results have happened here. But then this court said the court agrees, and they had argued that the claim was not pled with sufficient particularity as to this particular defendant. And then again, you see the court saying that Rule 9b of the Federal Rules of Civil Procedure require this pleading of particularity, which means the who, what, where, when, why. You have to show the specific ads. You have to do the precise misconduct with which they're charged. And so here it's just sort of, if you're not even saying like what the representation is, if 9b applies to this cause, and it'll at least apply to some of them, you have to be saying something about what was on his channel. And this complaint clearly would not meet any of that. You can see the next one, they have a civil conspiracy. That means people were conspiring together. I think the problem here is that once you have 9b apply to any of the claims, then so civil conspiracy is basically like there was this other what they call a tort. So you did something wrong and you conspired with someone else to do that wrong. And civil conspiracy can make you liable for the acts of someone else. If you were conspiring with someone, so the example would be like, let's say you don't rob a bank, but you're the getaway driver, you would still be legally liable for anything the bank robber is doing while they're in there. Your friends who's a bank robber, you guys get together, you say, let's go rob a bank. We agree to this conspiracy. It's usually not that specific, but then one guy goes in to rob a bank. The guy in the car is just as liable for everything else once there's a civil conspiracy. But in federal court, if one of the things that you allegedly did in the bank was something fraudulent, then you have to plead in civil cases specific details, not just for the original thing, that's that first cause of action we looked at, but also for the civil conspiracy, who, what, where, when, why, as to how you conspired. That's not pled here for BitBoy. And then the last one that we have is declaratory judgment. That's really just kind of a remedy saying we ask the court to declare that there's usually you pick something you want them to declare. A lot of times they do it in contract cases. This is about sort of whether these cryptocurrency things were securities, and so they're asking the court to declare that. So this is, I think that really the problem here, if I were BitBoy, I think I would be justifiably going, why did you not say anything about me? Whether it's true or not, ultimately, the lawsuit includes him in kind of a way as to where it really demands to go forward. You have to have some details about what BitBoy was saying. You have to have some allegations, and they didn't do that. And so this made BitBoy very mad in general, just having this lawsuit be filed. He did not like this. He started going off on social media. I do think, like, from a legal perspective, in this particular case, there's cases where stuff can be sort of grouped together. In the 11th Circuit, that is a lot harder. There are other circuits where this might have flown in some other scenario. I really think anybody looking at this in another circuit would have had a problem with it too, just in particular because BitBoy is unrelated to FTX in doing a different thing. He is not the same YouTuber as the other ones. If they were like a group of YouTubers running the same channel, maybe. But even for the other ones, it doesn't look like they show really the specific misrepresentations. That's kind of a problem too. You have to say something about what the advertising was or what the endorsement was or whatever, and just none of that's in here. Is it something that would nuke the lawyers? I don't think so. I don't think it's that bad, rises to that bad of a level or anything. But when I do say that he probably at least was right to be complaining in the substance, I'm not going to defend any of his complaints because I think he went way over the top. Or certainly if he's some of the ones we're going to see are attributed to him, including the death threat, that would be very bad. But as we'll see, we don't really know who made it until the FBI looks at this, which apparently they are. But there was some basis to be complaining about what the lawyers were doing here. Now, in defense of the lawyers, I'll say I think that probably what the plan was to amend this later. Lawyers do have a right to go before he even answers, or sometimes after the answer, you have the right to do kind of like one gimme change. But it is something where, like, I think probably you would have known this isn't going to fly the way it is, and that there was going to have to be some amendment of this later. It is just strange to kind of see it like this, because to me, it's like, why wouldn't you put in even something about it? But it is what it is. It certainly does not justify threatening people. but we'll go see now kind of what the lawyers say happened after this, because after this thing gets filed and you've seen all this, and this is what BitBoy's looking at, he's very angry, and they file a couple of notices that say, now actually give us details so we can see what they're going to be alleging later. So this is the document that kicked this all off, the drama here. And it did not give a whole lot of details. There were some news reports about this one, but there's going to be a second one that has everything that supposedly happened. This gives us kind of a high level, and it's just background for what the attorneys, how this all comes about. So the attorneys filed this shortly after they filed the lawsuit. They're still in the process of even serving everybody. So serving is when you go out, you've seen this on TV where someone goes and they hand somebody a paper and they're like, you've been served. And then the person looks at it and they go, oh no, there's a lawsuit. Oh no. So that's service of process. It's generally not as dramatic on TV. People get the idea from TV that they can go run away from this process server and dodge service. And if I just hide at my house, then I can never really get sued. Does not work that way. Absolutely. Well, Florida may be a unique. So I say that, but then Florida is a little bit harder than some states to serve people in. I've had cases where trying to serve them. You cannot actually get around it in the end because there are rules, and definitely in federal court. In federal court, there's a lot of broad discretion for the court to just make up a type of service. If they think you're hiding, you have to check a lot of boxes. It takes longer. You have to go hire a private detective. You have to go, I've had to go through all this stuff where you are just sending the police to their house. The sheriff will go try to serve things. You send private detectives. You have to get notes. You have to check on them and see, is there any other place they could go? Any place they could be, you have to go try. And then you go ask for what's called an alternate means of service. Sometimes that can be publishing it in the newspaper, like a little classified ad that says, "Hey, you're served. Sorry, nice try," or email them or send it to their attorney or whatever. Those are not normally you're supposed to be handing it to them in person, but the reality, the TV version is you can just run away. The real version is courts will just say, "I'm going to make the plaintiff attorney, try a bunch of things, but when they've done sufficiently enough things, tough." BitBoy does, the attorneys will be alleging that he tried to dodge service, that he was, even though he knew about the lawsuit, he was trying to avoid getting it. But it looks like they ultimately did get him served. They say in here, they asked for a status conference. A status conference is just a sort of a hearing before the court. And they want to discuss and address defendant Ben Armstrong's recent threats and harassment towards counsel. Ben Armstrong, again, is BitBoy. So they say, we filed this class action last week. We allege that these were influencers who promoted or participated in unregistered securities. And they say one of the defendants is BitBoy, who's a YouTuber with more than 1.5 million subscribers. They allege that he was paid to endorse FTX. It's pretty much all they allege about him, but that's what we just talked about. It says that shortly after filing this FTX complaint, defendant Armstrong began harassing plaintiff's counsel here in this jurisdiction with endless phone calls, tweets, and emails to him privately and publicly by posting insulting and threatening posts on Twitter, YouTube, and other social media. Armstrong's behavior has been quickly escalating. And it says defendant Armstrong has made numerous calls and emails to counsel's office, at times making up to 21 calls within a 45-minute period. And none of this is a good idea, by the way, if you ever get sued. It says defendant Armstrong has also left voicemails that specifically target undersigned counsel. That's the plaintiff attorney. The voicemails are not only full of vulgarities, but they also include warnings to Mr. Moskowitz, who is the attorney. We're going to have First Amendment protesters around your house 24/7, day and night. In another voicemail, the caller says that the home addresses of the lawyers are being circulated on Reddit. And that does sound at least a little bit threatening. The First Amendment protesting part is, more like threatening and annoyance, I guess. But we will see later an actual death threat. Who it came from, I don't think is entirely. It's not provable, I guess. It says that defendant Armstrong has harassed counsel via emails, such as the one below. Some of these I won't read the actual language, but you can see this. It says, Adam, hey, blank, profanity. Guess you do know who I am. More profanity. You are such an unbelievably dumb. More profanity, that you were leading a lawsuit against me when I never even promoted FTX. Expect a countersuit. Profanity. And then it says, hey, Steven, you didn't tell me that your boy here is suing me. He's a toxic ambulance chasing cancer. So it is insulting, not really professional, just hurling profanity. It does seem like BitBoy's angry with the lawyers for doing this. And his defense is that he did not actually promote FTX or was not paid for it, at least. The plaintiff says that BitBoy posted numerous aggressive and threatening tweets specifically targeting counsel. There's one where he says, there's only one person who better be careful, and it's Adam Moskowitz. I've already told him privately. And then they say that BitBoy posted a YouTube video directed at the plaintiffs and their counsel and says he's coming at them with full force. And then it says he encourages others to join the attacks, such as a recent post where he requested that his followers attack plaintiff's counsel. And it says, and this one is where one of the ones where it starts to get concerning. There's actually one in the more recent filing that is even more scary. This one says that Mr. Moskowitz, who's the plaintiff's attorney, received a message that warns him that these people are dangerous and can result in you and your family shot, which sounds like sort of a veiled death threat. At a minimum, if it's not a warning, it is either way. You do not want to be having someone leaving voicemails like that. And then this says this message prompted plaintiff's counsel to report Mr. Armstrong's recent attacks to the proper authorities, which we will later see. They state that there is an FBI investigation open. This says the plaintiffs are disturbed by the gravity of these, they call them aggressions. It's not the first time he threatened controversy. He filed a lawsuit against someone else, which is not really a threat. And then it says that they asked the court to take whatever measures and steps are necessary and appropriate and issue any relief that court finds appropriate to the conduct. And that's this filing here. And I'm going to show you a more recent one in a second that has even more stuff and the kind of a clean death threat in it. Okay, this is the filing that was made a couple days ago. Today's April 9th, and this was filed on April 5th, 2023. You can see that it's titled a Notice of Proof of Service and Materials for Show Cause Hearing. That's a little unusual. What they've done is kind of smushed together two things that are usually filed separately, but not really a big deal. But proof of service is when you file. So when someone is served with a lawsuit, you generally have to submit an affidavit from the process server. An affidavit is just a sworn statement, and the sworn statement says, here's the facts. I went down to this person's house. Here's who I served. Here's what he looked like. Here's when I did it. Here's all the time. And that's important to make sure that there's sort of actual proof that someone got served with a lawsuit before you go forward, to make sure that they know about the suit. That's kind of the key thing, is making sure someone knows and doesn't just get blindsided with a lawsuit they never heard of, and so they get a chance to defend themselves. And the other thing we're filing are materials for show cause hearing, which is just stuff. I mean, the way that's phrased, it's basically the court is going to have this hearing that we talked about, the show cause hearing earlier, which is when the court's going to decide what to do about BitBoy and what to do about these alleged threats. And at that hearing, this is stuff that is being submitted for the court to look at in advance of the hearing to consider when making its decision. So this says, after many weeks of evading service, but continuing to make daily violent threats towards undersigned counsel, the attorneys, and plaintiffs, here is actual video of defendant Armstrong finally accepting service this morning. And if you go click through this or look at it, it's not he's not actually accepting service. It's a video of BitBoy on his channel tossing around a copy of the complaint, angrily cursing at the attorneys and saying that they're going to regret having done this. Or that's rough language, but saying that they're wrong and all this. And so he clearly does know about the lawsuit from the video, although it's not video of him accepting service. This says that Mr. Armstrong self-proclaims to be the people's champ, but he has a demonstrated history of earning great amounts of money at the expense of his unsuspecting social media followers, has been named in 2 separate class actions pending in this court for his role in soliciting the sale of unregistered securities. And the PAFRAF one is the one we're looking at here. That's this lawsuit. But there's also this other one, Sizemore versus Zhao et al., which is in the same district, Southern District of Florida. But that one's about promoting Binance and Binance's BNB cryptocurrency, but kind of filed around the same time. So it does look like multiple class action attorneys were kind of looking at Armstrong in the same time period, although I wasn't able to find any others on BitBoy with FTX and FTT. So it's not clear where these attorneys, like, why is there no details in the first lawsuit? I'm still a little unsure on that. This appears to be kind of an effort to correct that, because when we start going through this, we're going to see not only stuff about the threats that were being made, but also stuff about kind of what BitBoy was allegedly doing that would have violated these Florida laws. It's all the kind of stuff that I would expect to have been in the lawsuit originally. And frankly, I think they're going to have to do this for every YouTuber they sued or every influencer they sued, showing specifically what representations they're saying, what things they said on their channel that give rise to the lawsuit. And that's the kind of thing where you would expect it to be there because it's all public. And so it's not something. Sometimes when attorneys are pleading lawsuits, or really all the time, if you're talking about something where only the defendant would really know about it, like who runs BitBoy's channel, if he has if there were a group of people running it, like who does exactly what, the plaintiff has more leeway to sort of allege, like, this is what I think happened, because you don't have the documents. You aren't in their organization seeing what's happening. For stuff like an ad that's out on the internet, or stuff on BitBoy's Twitter or on his YouTube or whatever, the court's not going to give them leeway because they can just go to his YouTube and find it. And so the court would require them to put it in their complaint ultimately at some point for it to not get dismissed. We're not at that point yet, though. Like I said, they will get a chance to amend this. And I do suspect that they were planning, they probably knew when they filed it, they were going to have to add more stuff. And I will say as well that while I do think that this complaint is filed is sort of frivolous in the sense it has no chance of winning as filed, that's sort of it's not like maybe even a traffic ticket level offense. It's the kind of thing, if the court looks at it, the court usually is just going to be like, look, go fix this. You get one more chance. And frankly, they can do that before the court looks at it. With the federal rules, they get this sort of one free amendment, which they probably were counting on. What we're seeing here, the reason that they're dumping all the details that really probably should have been in the first complaint into this filing is because they know the court's going to look at this. And I suspect the attorneys are probably going, well, if the court reads the first complaint, it's going to see just one line about BitBoy. And so we need to go actually say what we're suing him about, especially given that that's what he's kind of ranting on YouTube about. I didn't do this. So they say that that's just sort of background for what you're going to be seeing. This says Armstrong confirms that he has notice of the suit. He starts posting videos about the allegations in this lawsuit the day after it was filed. You can see the text here. I'm being sued for $1 billion in a class action lawsuit. And then he immediately this alleges that BitBoy immediately began attacking plaintiffs' counsel, the attorneys, and their families. The scope of the attacks, including death threats, which examples are provided in those filings and which continue on a daily basis since. Here's the key part of all this, necessitated undersigned counsel to open an FBI investigation into Armstrong, as well as the investigation files by local police authorities for plaintiff counsel and their families. Okay, and so what this is saying is that the attorneys here, the counsel, have gone to the FBI about this and opened up an investigation into BitBoy. Does that mean that something's going to happen from it? That certainly means, and when you see the emails and the death threats below, it does look very clear to me like whoever sent them is probably going to have the FBI up their derriere. That's the way to put it. The FBI is going to be on whoever did it, whether that was BitBoy or not. The emails kind of doesn't say, "Hey, this is BitBoy," and sometimes even if it says, "Hey, this is BitBoy," with someone who has that level of kind of followers, people will start trolling. They may it is possible to go spoof some of this stuff, but he certainly is saying things clearly in public that sound very angry and a little, not happy about all this. But whoever did send some of these emails that are just plain threats are they're probably going to get tracked down. They went to the local police authorities it says local police authorities for plaintiffs' counsel and their families, which means they went also to the police in whatever area they live in, which means that's largely to sort of the ones who probably will track down who's behind any of this, or the FBI. The local authorities are going to be like watching houses and that type of stuff to make sure no one's doing anything nuts. And certainly nobody should be making death threats, period. End of sentence. Then this says that the chief judge, who's in the judge on this particular lawsuit, granted the emergency request and sent it to a magistrate judge to take necessary action. A magistrate judge, so there's two types of judges. There's just a regular federal judge, who's the one who gets appointed by the president and gets confirmed by the Senate. But then you also have these magistrate judges who are kind of, the best way to think of them, if you're not a lawyer, is like a helper judge. They are federal judges. They are not appointed through Congress. They get kind of terms that are, I believe, 10 years long, but they're kind of appointed by consulting with the federal judges who have gone through Congress. Those guys kind of get together, they take applications, they look at people, decide who's going to be a magistrate judge, and then the magistrate judges are on their cases doing a lot of like the grunt work that the federal judges don't want to do. So it's a very good position. It's definitely like a high up position, but they also get assigned like a lot of the detail work, which is why that magistrate judge got, go do this, go look at this. So then this says that same evening, BitBoy responded to a service email sending the notice of filing and request for status conference. So what this is saying is like basically the lawyers email him that thing we looked at a minute ago that was saying, hey, someone's making threats against BitBoy's making threats against us. And then these attorneys are saying, well, then BitBoy just started levying more threats and hurling additional insults. And this is an email that to a bunch, you can see these are all like attorneys. They're responding to something, which is the service. They probably just emailed him and said, "Hey, BitBoy, here's this thing we just filed," in probably more formal language than that. But then this comes from Ben Armstrong and says, "Hey, all, just wanted to let you all know that I received this notice and I couldn't be happier. You're also kind to let me know you are all dumb." Blank. I'll omit profanity, especially that one. I've been waiting on this so I can file my countersuit. You are all profanity. I am. You are all in serious trouble is what he's saying. In translated into less whatever. And it says, I'm going to not only sue you and win easily, but I'm coming for all of your blanking licenses. You don't understand who you have blanked with, but you will. Thank you, Ben Armstrong. Now, I will say, I wouldn't really call this sort of talking about this in terms of a threat is a little bit of an exaggeration. He is threatening to do stuff, but it's not stuff that he's not entitled to do, right? He is entitled to file countersuit. He is entitled to sue, or I'll say in terms of entitled, I don't necessarily mean he can win that, but he is like, it is not saying I'm going to countersue you is not something that is wrong to do in the same way that threatening to like go to your house and do something to you is. So they are conflating that a little way. He is hurling insults. I will agree with that. But also saying I'm coming for your licenses, your attorney license, is also not something that you can't say or even go do if you want to go report it. Now, do you have a basis to do so? I don't think so here. I think even though I've kind of have been on looking at this lawsuit going, I don't think the first version that they filed is really like stand up. That is not something that the Florida bar or any bar is really going to look at and go, that's something that's a problem with your license. Even a judge will not look at it and think it's like something that I need to do something about. It's more like, if you stick with that complaint and you don't flesh this out, you are going to lose your lawsuit. So he's not going to get rid of their bar licenses by doing this. He may think that, but that's probably not going to happen. So I would say high confidence that does not happen. I will also say, for sure, BitBoy should be not emailing these people personally, and he should be getting an attorney, not only because he appears to be having temper issues with this, but it is a bad idea to be sending all this personally. It's one of these scenarios where anything you say can and will be used against you. I am sure that a lot of this will be, to the extent the attorneys are able to do it, they will be trying to use it in court. They will be trying to use it at a trial if there is a trial. Very unlikely there is a trial, because class actions very rarely go to trial because of the serious consequences and how sort of life-ending it is to lose. And certainly in this case, if he lost, he would have a lot of problems. But then this says that plaintiff's counsel, so he apparently keeps doing this stuff, and we will see later, he does look like he has an attorney, but just is not letting that attorney do the work, which is the problem. So it says that the lawyers for the plaintiff served this thing on BitBoy in response to his daily reminder that you are a blank email, to which BitBoy responded, "Oh, don't worry, it will be returned this week. I can't wait." And a request for a waiver of service is, you in federal court, to try to save money on service, you're allowed, and just not to be sending around process servers to everyone. A lot of times you can you don't have to, but if you think that the person might sign it and say, okay, I waive it, you can send them just this document that's like, please waive service. And if you don't, you have to pay like a little extra fees, not that much. If generally, most people who are represented by attorneys will just waive service of process. Once an attorney talks to you, they can sort of, even if people think, I saw on television that someone can run to hide from service, the attorney will generally tell you, like, look, there's no point to this. You're wasting time, and it doesn't look good to just try to dodge service. But he did not return that waiver. This says then the attorneys say they received an email from a Mr. Lionel Iruke, who purports to be general counsel with BitBoy Crypto, making a limited appearance on behalf of Ben, who inquired as to why Armstrong was included in this lawsuit. To date, Armstrong nor his alleged counsel have ever responded with the waiver, as he indicated he would. Now, I'm not sure why they were calling him an alleged counsel, because I looked up this Lionel Iruke. I'm not sure how to pronounce his last name, but that's sort of, I will say, if I got it wrong, I've received cosmic justice many times over with people trying to figure out how to pronounce Nooper. But this is a real attorney, okay? So you look him up. He's got a LinkedIn. You search his last name, and LinkedIn says he's licensed in Texas and California. I searched in both states. He is licensed in both states, so that's a real guy. His name is like apparently a Americanization of the way his name is actually spelled, so that it may be that they searched and find him. It may be that they just didn't look. I don't know, but this is an attorney. So why BitBoy has an attorney and is not letting that attorney handle it, I don't know. Maybe it's just because it's getting him a lot of attention on YouTube. It is for his lawsuit, not a good idea to be doing, because doing this stuff is just, he's going over the top, I think, in terms of just things that he's saying. Certainly, if he did the death threat, he's in big trouble. But that is for the FBI to say. I do not know the answer to that. This says then, true to form, so shortly after this Zao was filed, Zao is the second lawsuit about Binance. Armstrong began tweeting to his millions of followers more insults and threats to plaintiff's counsel, the attorneys, while clearly acknowledging his actual receipt and awareness of the new lawsuit. And this Adam is the name of the attorney. He says, "This is how dumb Adam Moskowitz is. He's suing me for promoting unregistered securities through affiliate program at Binance. What evidence does he use?" And now that is, at least for this lawsuit, there is not a lot of evidence, or any evidence. Now there is, but in the first one, BitBoy would have been responding to, he would have just been looking at that one sentence. He uses quotes from the CFTC action versus Binance, the one where they call those commodities. So commodities, that's kind of a big legal question. Are cryptocurrencies securities, which have heightened regulation, or are they commodities, which have a different kind of regulation? But he does appear to be talking about the separate lawsuit here. So I haven't read that one. I don't know if that one had more evidence in it, but this one certainly does not. Then this says that the lawyers again sent to BitBoy and to Mr. Iruke the notice of commencement of action and request for waiver. That's what we were talking about earlier, the waiver of service in the Zao action. And that's the second lawsuit. Then this says, this time, rather than respond to the email as he did in this lawsuit, BitBoy stuck to posting more Twitter insults and attacks about plaintiff's counsel. And now he's getting a little more personal. So above, he's just saying that he's not using any evidence, and he calls him, dumb, which is not nice, but not crazy. and then now he's going a little more extreme. The attorney's literally a walking piece of human garbage, and then he starts posting pictures of him insulting their appearance. Hi, my name's Adam. The best I could do in life is literally hunt down plaintiffs to do my bidding and get me some money. While my 5.3 million plaintiffs have made an average of $1,113 each, I made almost $2 billion. Got to make mama proud. She loves watching down on me as I screw clients, which is that. And that's, I don't know anything about whether these numbers he's saying are true or where he's getting that from. Now he starts making fun of the appearance of one of the partners there, who does look a little younger, but he says, imagine looking like a giant baby for your whole life, LMAO. This must be Adam Moskowitz's, and I won't read that, but he's making an insult based on, a sexualized insult, which it's kind of over the top. And also this guy the other attorney may be like just some junior partner there. So it's really not why you're going after him. I don't know. There's no real reason to be doing that, but other than BitBoy seems to be very mad about all this. Now this gets into some allegations about the service and what was happening there. More drama basically all over everything here. So they say that contrary to what he was boasting to his millions of Twitter followers, it appears that BitBoy had no intention of willingly appearing in this federal court matter. So it says they attempted service on his house in Georgia, and then BitBoy instructs the guard at the gate to refuse entry. And then it says they also tried to serve him at his BitBoy store. I guess there's a BitBoy store that you can go to. And this says that his assistant accepted service on his behalf at 3:39 p.m. In abundance of caution, the process server waited and observed the store from 4:20 to 6 p.m. At 6 p.m., the partner told the process server that BitBoy was filming, could not come out, but he'd make sure he's available tomorrow at 12 p.m. But then they said that when he was supposedly filming, he was tweeting a picture of the summons, acknowledging that he was in possession of the materials that were served on his assistant. So basically, they're saying, look, we gave this to the assistant, but he clearly has it because he's, posting pictures of it on Twitter. And then BitBoy is sort of insulting the attorneys again, saying Moskowitz can't even find the simplest information. These shouldn't surprise anyone based on his track record in these lawsuits. He said, I was running from my summons, LMAO. No, dummy. You tried to deliver it to a state I've never lived in, to the wrong person. What an idiot. So apparently they tried to serve someone with the same name, Ben Armstrong, in Chandler, Arizona, and BitBoy lives in Atlanta. And so they say that they affected the service on him through serving his agent designated to accept service of process. And he confirmed that he did actually receive it and has been participating in lawsuits, or these two lawsuits, I guess now for weeks. I'm not sure how he designated the agent. That's not really clear how this person was sort of, designated to accept service of process, or whether he the assistant is saying that he did it. I mean, so normally a corporation can designate it, or has to designate an agent to accept service of process. A person could designate an agent, but doesn't have to. And so I'm not really clear on whether is there an issue with the service that they're trying to sort of say, oh, he actually did physically receive this, versus, why did we give it to the assistant? And I kind of stopped a minute here to go look up law on this to try to figure out what's going on, because I do think there might be an issue here. Service of process. So in federal court, you kind of have three ways to do the service here. Federal court lets you use the law of either. So in this case, it would be Florida for one. You can use the state where the lawsuit is pending. So in a federal court, so they can go use not federal law but state law. They could use the federal law, which there's a generic federal rule in the rules of federal civil procedure that lays out certain ways to serve people. Or you could use Georgia law, which is the state where the person you're serving or the corporation you're serving resides. Here it's BitBoy lives in Georgia. So they have those three options. Florida is not the one I would choose because I've tried to serve there before and it's the least useful one. But Georgia, I think what they're relying on, Georgia law does have a provision that says that you can serve someone through an agent that they appoint to accept their service. But they're not really saying that. They say it. They say that the assistant accepts this and service was made on this assistant. The problem here, what makes it strange, is that they say that this service happened at his store. So in Georgia and really a lot of other places, this is sort of the general rule and the federal rule. You can serve it on a like an adult who also resides at your house. So if you go to someone's house and there's an adult, you can go hand it to someone, or maybe even someone who's just there as an adult who's likely to give it to them. It depends on the state. This is not at the house, so it couldn't be a service at a residence. It's at a store. But then it doesn't. I'm not sure how this person is being appointed to be his representative. There's nothing really saying that. And I was also a little curious that they say this is a proof of service, but usually you have a sworn statement by the process server, and I'm not seeing that anywhere in this document that I downloaded. So I am wondering a little bit whether this is sort of smoke distraction smoke when they start saying this, that maybe there isn't actually service. They talk all the time about how he does know he has actual notice, is what is called actual notice of the lawsuit. I do think eventually they're going to, this is going to be enough long run for the court to give alternate service, but I have a lot of questions here about whether this is really, service has actually been affected now, which means the court might get to this hearing and really not be able to do anything to BitBoy if what I'm looking at is right. He may not really be in this lawsuit based on what I'm looking at here. And they talk about, they have a footnote here. Footnote's just like a little oh, this isn't part of the main document, but I'm giving you a note. BitBoy had been complaining about the Arizona address. They say that they did a skip trace. They came up, a skip trace is like a search through databases for where someone lives. And the most recent address for Ben Armstrong with this birth date was in the Arizona address, but they said now they've made services at this Georgia address attributed to him instead. So apparently there may be someone who has the same birthday, but also the name Ben Armstrong. Not very surprising to me because Ben Armstrong is not a uncommon name. So I did actually start digging around again just to see kind of what's going on with this. And it does look like there is a separate proof of service filed separately. So they filed this one first and called it a proof of service. And then 2 days ago, so after the thing we were looking at, they filed this document, which is it says it's a proof of service for Ben Armstrong specifically. So this is a process server swearing that they served. You see the within named person, and that's the person that is sort of listed here, and it says at the top here on Ben Armstrong, and then they describe him as a white male. They give the address, which is this, and they say it's a white male, 55 years old, 220 pounds, 6 foot, gray hair is the person that they served it on. I will say BitBoy is 40 years old, although maybe he looks a little older than 40 if he's been going through a lot of stress. And it seems very likely that the process server would have served the right guy since he's all over YouTube. They're going to have photos of him, and that even though the age is dramatically older here than what he actually is, sometimes people look a little different ages. And if BitBoy's making fun of other people's ages, then he can't really complain if anyone takes a shot at him there. So, okay, so this has sort of they're relying heavily on this Twitter thread, and basically they say Armstrong was making these challenges, I'll give you $10,000, you can find and prove an undisclosed promo. They don't exist. They claim that this Zach XBT guy took up the challenge, and within minutes found a clear example of Armstrong promoting a crypto project without disclosing he was paid to do so. And so there's some screenshots there of this Unreal cryptocurrency apparently being used by Meta Legends, and NFTs are blasting off now. This is wild. So, and then he says, here's some wallets. So they're apparently tracking down on the wallets, things that BitBoy is showing in the video. Looks like he's showing his wallets on the video or something, which is maybe not a good idea. And then this says that BitBoy publicly admitted that Zach XBT was correct, but claimed he was shocked, and he blamed his employees for the mistake. So it does look like BitBoy does have a bunch of employees on the channel, which is one of those things kind of where, in terms of what you plead, they wouldn't know which employee did what. But you can decide, you can figure it out based on their role and make kind of a pleading if you're the CEO of the company or the guy who writes the ads or whatever, then the CEO probably knows what's going on and probably is involved in a lot of the stuff just based on their role. And that can get you there in a pleading. And apparently BitBoy then pays this guy the $10,000 for catching it. So the guy says, BitBoy sent me the 10K. Then now we get to the stuff. These are kind of things that they really need to put in their complaint at some point. Contrary to his public statements, there's a wealth of public evidence that he specifically promoted, BitBoy specifically promoted FTX, FTT, and Sam Bankman-Fried for financial gain. And they say that they're accusing him of trying to delete stuff from the internet, but they say that a bunch of people are saving it. Some of it is like, here's a quote of him saying, Sam Bankman-Fried, everything this man touched turns to gold. Let's talk about the secret token FTT. And FTT is potentially going to be one of the few coins, I believe, that could go up in the bear market. Now, I know that sounds crazy because I tell you hardly everything ever does. They have them saying we could see FTT just absolutely rip. Then this one says, Armstrong saying, to crypto crushers, why I put 1 million in these secret altcoins, and it says he put $500,000 in FTT because he got information on FTT that just made him say, man, I got to go ham on these coins. And then they say he continues and said, now FTT, I said before, this is going to be one of the number one coins we're going to accumulate in this bear market, but got some inside info that this thing is about to explode in the next few weeks. And he concludes, look for FTT, sorry, I jumped around. I think I might have, look for FTT by Christmas to absolutely moon. A lot of money is about to come pouring into FTX. Now, this is part of the reason why people want to regulate crypto as a security, because what he's saying, like, if this is a stock, you're basically saying I have inside information about this thing, like, or something about it. And it is definitely, you kind of need it to be a commodity or something else, or really maybe it's the kind of thing that calls out for regulation, I guess. Then this says, other users have been publicly calling Armstrong out since he claimed he never promoted FTX or FTT and was ever paid to do so, by including by identifying the agency that likely paid him, Coinbound. So this is another person tweeting, someone named becauseunderwater.com, cardboards are screaming. So the ultimate credibility of that guy, I don't know, but he says, bro, you said one of the biggest coins of the year, gotta do phenomenal, and you even gave SBF a 5-star rating. 2 months later, they went bankrupt. And then he shows like a thing with BitBoy saying, so we have this in our $25,000 portfolio. Looking for this Coinbound. Here's someone or the same guy. The cardboards are screaming guy says, bro, read the suit even. Doesn't claim he was paid by FTX, only paid to endorse FTX. What if he was paid by coinbound.io/influencers to endorse FTT? So they cite this cryptocurrency marketing agency. This doesn't really say why this guy thinks that, but it might be enough to sort of, if you're doing the lawsuit, to allege. It looks like people are alleging this, and I'm not sure what the basis for the speculation is, but in the first complaint, you don't have to have all your evidence. You just have to have kind of a basis for saying that, and that probably is going to be enough for them to allege that. Then this says BitBoy also publicly disclosed his own portfolio for followers who wanted to like emulate the portfolio based on his success and his savvy in cryptocurrency. And his portfolio had showed that he held $437,000 in FTT, which was one of his larger holdings. You can see if this is true, BitBoy has, it's probably down a lot, but he still would have millions upon millions of dollars just from Bitcoin and Ethereum. And then they say that Armstrong has said time and time again that FTT is a top altcoin pick, and he made a bunch of videos promoting the coin. And here's sort of some of those videos. Then they say he's an admitted Binance affiliate, so he promotes, even if he doesn't promote FTT, he's promoting Binance's platform. And part of what they're doing here is basically sort of trying to make an inference. So it sounds like if you don't have evidence that he's promoting FTT, it does at least tend to show that he would be promoting FTT for money if he's doing it on other coins. That's not like, you couldn't win the lawsuit. I don't think you probably, like, that would be not enough to get to a jury on alone, but it is probably enough to get to what's called discovery, where you go actually like get to get emails from BitBoy, get to get documents from him, get to get documents from FTT to find out. These are the kind of things that are enough to kind of get past that threshold, but you in sometime in discovery would have to go find like real proof, not just things that like circumstantial evidence is what we would call this. And in this case, it's for a trial, it would be very weak circumstantial evidence. But for a complaint, I don't think it is. For a complaint, I think that if they stick this into their complaint, they're probably going to have enough to get past motion to dismiss on that stuff. So then they say Now they kind of get to this stuff, and we're going to go down because they actually attach some of the other threats that we haven't seen. They say the plaintiffs respectfully suggest that any court cannot condone or allow such inappropriate, bullying, unprofessional, and frankly terrorizing conduct when there's millions of people on social media. It involves direct threats on officers of the court and their families. The attorneys are considered officers of the court. It's not like an official office, but it's a phrase that means you have sort of legal duties to the court, and you are before the court in a capacity that makes it not official, but just kind of official. And then it says everybody deserves a chance to voice their opinion, but they can't be allowed to threaten officers of the court on social media. Let's make an example of him because he continues to wear of BitBoy. Because they say he continues to wear his bullying and assaulting conduct as a badge of honor, and that he's been, despite crying innocence, he's been involved in nefarious activities and shilling crypto projects with pump and dumps and charging tens of thousands of dollars a mention and providing a plethora of materials regarding these guys, the Sam Bankman-Fried, and being an affiliate of Binance. So now a lot of that is like, I don't know. I mean, he may have pumped this stuff, but they are kind of like, it's not necessarily nefarious if it's disclosed, or if it's like, with crypto, the problem is some of this stuff is like, if you know it's trash, you shouldn't be promoting it. And that may be kind of the issue. But on the other hand, like the stuff they're showing about promotion is really just him kind of, I don't think it really, it's like saying, oh, I have it in my portfolio, or saying, oh, I invested in it, or, oh, I think it's good investment. I think really the question is going to be, is he paid or not to do this? If he wasn't paid, it does seem hard to see how that alone would make the lawsuit go forward. But there is enough to sort of infer that he might have been paid. They just have to go kind of find that out. And there's not enough really now to know, like, as a lawyer, like, can I condemn this guy on it now? I don't know. On his threats, we do see him going a little, we're going to start seeing some of this stuff here. So that these are just documents, but now they have exhibits. They have a declaration. So this is one of the things where a person swears under oath to something. There's a paralegal at their law firm. She says she got an anonymous number. The person on the line was a male voice, asked for Moskowitz, began ranting about the First Amendment rights, became vulgar. So she hangs up the call. And then after the paralegal disconnects the call, she starts getting just 21 calls total, and they have a call log. She gets 3 voicemail, which are transcribed automatically. They get a form submission page that has threatening emails, and we start seeing some of these. And again, these are anonymous. They are just a bunch of calls. There are these are the recorded, like the transcribed voice messages. Another class of him, and they may be a little inaccurate because sometimes the voice doesn't get recorded or transcribed properly. Another class of him doing this because I simply couldn't believe it when I saw they're playing games with people's lives. That's not right. I'm to expose a few accidents, what they really are. And what can I say? That video in a month before FPX class. And to be clear, I'm not claiming that Big Boy, it's horrible. I think it was locked under. Then why do you guys hate free speech? So type of loan, we're going to send First Amendment protesters. I believe in free speech at your house, where each and every one of your lawyers sleep at night. All your home addresses are being sick. They don't read it. You can tell some of this is probably something a little bit different. Hey, it's Adam asked, was there that little blank blank boy? So you never heard of the First Amendment? If you think if I go on YouTube and say, hey, my personal opinion I like such and such company, but I guess isn't financial advice, don't buy them. But my personal opinion is like, yeah, I think they're okay or whatever. And then like a year later, that company goes bankrupt. You think you can probably sue me, see me, sucker. So we're going to have a First Amendment protester around your house 24/7 day and at night, or you're going to learn about free speech in this country and you're blank little. Are those BitBoy or not? They sort of sound like they might be, but that's also is from some anonymous number. Then this says, this is an email. You can see this comes from some submission form from like a Bart Simpson prank call number and a Bart Simpson prank email. I won't read those because they're, borderline profanity or probably are profanity. You're blanked, filing frivolous lawsuits, prepare for hell. You were humiliated today. LOL. This is like some kind of fake name. Proton Mail account, which is anonymous, the number 12345678990. You're choosing war with an anonymous community while you yourself are not. Only a couple Bitcoins get you and your family shot. Please be careful. These people are dangerous and you have provoked them. So that very much sounds like a threat. And whoever did this is probably being investigated by the FBI. We don't know. We can see near when those calls were made. March 16th. So like maybe the day before those calls. Now, some of this, the thing that you don't know, or at least if you're going to make both sides, or the argument of the other side, is that there's some chance that when BitBoy is out, what could be happening is he's out there ranting on the internet about this stuff, and he may be talking about suing and whatever, or protesting, but then other people in his sort of following are getting riled up to the point that they start doing stuff that they really should not have been doing. And so I do suspect this will be tracked down, whoever's doing this. And so I don't know. I have no personal knowledge of who did it or did not do it. There is at least some chance that the FBI will go find them, and it'll be some totally different person. And probably, I don't know, significant enough chance that you who knows who it is. Or there could be more than one person. It could be BitBoy sending some of these. It could be other people sending others. It could all be just random fans. It does appear at least some of these came from him, or some of the emails and stuff came from him. But the ones that are kind of this threatening and talking about your families getting shot and paying Bitcoins to do it, I mean, that's going to get you in trouble. Do not do stuff like that. Do not even think about doing stuff like that, because people can get tracked down in ways they don't think that they can these days. This one does appear to be coming from his email address, which also can be spoofed sometimes, but this also appears to be like a chain. So that makes it less likely, because this first it has him in kind of like a more polite, like normal email. But then you have this follow-up that's like, hey, blank, guess you do know who I am, blank. You are such an unbelievably dumb blank that you are leading a lawsuit against me when I never even put it FTX, expect a countersuit, blank. That's kind of, we saw that a little earlier. But this one appears to be from him, from BitBoy. Then they have these public tweets. This is getting a little personal again. Hi, my name is, this is BitBoy saying, hi, my name is Adam Moskowitz. I'm an ambulance chasing blank who cannot even do my own due diligence on crypto lawsuits. I have zero integrity in a super small blank, which I actually tried to sue my own mother for. But just like all my other cases, I lost that one too. He says, like, WTF, lawyers chiming in saying I better be careful. LMO, you have to be kidding. There's only one person who better be careful, and it's Adam Moskowitz. I've already told him privately, you do not get to make lies up. You will be held accountable. That doesn't really rise. So if that's standing alone, it doesn't rise to a threat. I will say that that I can see why the attorneys are concerned about this, giving the guy talking about using Bitcoin to pay for an assassination or whatever. That's something where that definitely, in the context of all this, they for sure, I am not surprised they went to the court. I'm not surprised they went to the FBI, and the FBI will hash out all this. Then now he's sort of urging people to go take action. And this is where he might be doing stuff that is, even if he is talking about he says, leave a review for Adam. His law firm Ambulance chases crypto cases. This is a big reason why the government is able to run roughshod over our space. Man up and do your part. Let these people know we won't take it anymore. So he's encouraging people to go do stuff. And he is saying do a review, but the problem is when you start doing that to millions of people or whatever, the chances of somebody deciding to just be nuts goes up. If you say something to an audience of tens of thousands of people and one of them's crazy, then you can see somebody deciding to do something dumb. Then BitBoy says, countersuit coming. The lawyers in this case can't possibly be more stupid. I've never had contact with anyone at FTX and never even had a ref link. Show me you were dumb without telling me you're dumb. I'm going to roast these low IQ plebs and their lawyers, which again is not a threat. But again, he probably should not be telling people, just go out there and do stuff against the law firm. If he's, stick to the countersuits and then the legal system, and you're in a much better space. Then he shows a review he left, and he says, I did my part. And his BitBoy's review said, Adam Moskowitz is the worst scum of a lawyer known to man. In fact, his license will probably be taken soon because he has an established habit of ignoring due diligence. So again, he's ignoring people to sort of review bomb, he's imploring people to sort of review bomb Moskowitz's firm. Doesn't look like, or at least when he did it, there was only 8 reviews. And then someone else starts posting memes of him chasing Moskowitz. So I think the lawyers are posting this to show people are kind of starting to respond to this. Then BitBoy says, I'm contacting the state of Florida today about going after Adam Moskowitz's license to practice law. Not only is he shorter than the average American male, he's also a really bad lawyer. Again, I don't think the state of Bar of Florida, even despite me believing that this lawsuit is not fleshed out enough to survive, that is not something that is going to cause a problem for their license to practice law. It is something that causes a problem for winning if you don't amend. And you can see these are some of his tweets from where he's talking about FTT. Then this is the thing. We looked at this document earlier. That's their original request for this hearing. And then he's sending, I think we've looked at this stuff earlier. You can see they're attaching copies of these emails where he sends this stuff, but they're sending, it's just sort of BitBoy again. You can see him saying, LMAO, dummy, yeah, I got it. I responded directly to your email, so I'm sure your low IQ and inability to perform due diligence is coming into play here. You guys are so far off base, including me in this lawsuit. It isn't even funny, and I can assure you I'm going to make you pay big time for this. You obviously have your facts wrong. I've never called you. I wouldn't think if you haven't figured it out by now. I own everything I do and nothing I don't. So BitBoy is saying, they came to him, I guess, and said, hey, you called us. And he's like, no, I didn't call you. So BitBoy is denying he made these calls, or that he was behind it, and I assume will before the court. Does not necessarily mean that he did not just insult them enough that some crazy person has decided to do something about this. This is the email from Lionel Aruke, who is a real lawyer and probably should be handling all of BitBoy's responses. But you can see this comes on March 29th, and that is after a lot of BitBoy's sort of ranting and stuff in chronologically, which means that BitBoy may have wised up and gotten a lawyer to represent him, which, by the way, always a good idea, especially if you have this much money at stake. Now they're sending it to him. This is the process waiver or sort of insults. And so that's the end of that document that's been filed, and we don't have the hearing yet, but that hearing is likely going to be scheduled, and then we'll see what I guess what BitBoy says, but also what the judge thinks about this. So back to this sort of materials that they were submitting for this hearing. So there's him having the summons. So it looks like even if it was an issue as of this date that this was filed on April 5th, they corrected it after, and now he has been served with all this. And so BitBoy is in the lawsuit. Now they start to get into sort of like this kind of stuff that I think that will ultimately be amending their lawsuit to put into it, and the kind of stuff that you really have to because it's public. So there's no sort of basis to say, oh, I can't find out about this without discovery, or I don't know the exact details. In a complaint, a lot of times so as the plaintiff, you don't know all the facts for certain. Even in a civil case, it's 51% chance. It's not like a criminal trial. The burden of proof is more likely than not, even 50.1% chance. You don't have to prove everything by like beyond a reasonable doubt. And at the very earliest stage, you don't have to sort of know to a certainty what's going on. You can't know to a certainty, but you do have to investigate and kind of have a reasonable basis to think what you're filing is going to end up to be what's true. But you do have to put it in there, or at least allege it. So, and certainly for false advertising type stuff, you've got to show what the ads are. You may be able to, like, in terms of who wrote the ads or put the ads out there, or if it's like a company or a group of people or like a YouTube channel with more than one person behind it, you wouldn't have to give as much detail on who did what, but you would have to show, like, look, here's the ad, like literally on his YouTube account. So now they start actually doing that, and they say, as you can see, based on publicly available evidence to date. So this is what they have and what they can rely on. They say he's long promoted FTX, FTT, and Sam Bankman-Fried to his millions of followers, and is indisputably an affiliate marketer of Binance, for which he derives personal financial gain with his own referral code on the Binance platforms. This is their other lawsuits. They're sort of using that to sort of bootstrap over here that he's probably doing it on FTX/FTT as well. So this says, there's sort of some more colorful language. It's in this video that they were talking about earlier where he says, I'm going to bury you. It's not necessarily a threat, though, because he's talking about countersuits and stuff like that and law licenses. This says that BitBoy has a history of shilling crypto coins to his followers for pay and then attempting to conceal the evidence. That's what they're alleging. They say there's no dispute billions of dollars have been stolen from class members in FTX, Voyager, and Binance, which actually there is probably no dispute about that, that there's been these disasters. And with all the federal bankruptcies, most of the victims may only see recoveries from those aiders and abettors who promoted these unregistered securities for their own financial gain, which is also probably true. Then this says that many social media influencers have already documented BitBoy's long history of specifically promoting unregistered cryptocurrency tokens. And you can see they have a little note here talking about how all these crypto companies knew the only way to compete was to get a bunch of affiliate programs in a pyramid structure and They retain the most well-known and world-famous celebrities to tout their unregistered products, and that is definitely, there's been a ton of people just like touting cryptocurrencies without looking into them, or selling people NFTs or whatever. And there's a lot of reason why we had all this sort of Ponzi type stuff is because influencers were doing stuff that they really shouldn't have. What specifically about BitBoy, what he was doing is something for the lawsuit to decide. Now, this talks about kind of a takedown. So Tazi, this YouTube internet person, I'm probably pronouncing that wrong too. YouTube internet personality posts this 11-minute video in November 2021 that details how Armstrong has one of the largest crypto channels, but has also been known for being a shady dirtbag who milks his audience for a quick buck rather than giving them genuine advice. And then they show this quote: "You don't know if he's trying to enrich you or himself. Here's probably an example." It says this other YouTuber details Armstrong's vigorous promotion of the PAMP network, which Armstrong, BitBoy, claimed was guaranteed to go up in value, but which quickly tanked when the truth was finally revealed after he made his promotions, alleging that BitBoy was paid to shield the project to his fans so the project owners could create exit liquidity and do a rug pull. A rug pull is sort of when the people who start the project go pull the rug out from under you, and they end up getting rich, sort of selling out or whatever, and everybody else is stuck with a useless crypto coin with a animal picture on it or something, or whatever their pitch was. And they say, go watch this video and you'll see his methods of doing business. Then they say Armstrong, BitBoy, sues this Atazi guy, claims he defamed him. But apparently they're alleging that BitBoy didn't know the lawsuit would be public. I don't know how you wouldn't know that. But then they say that he had to drop the lawsuit, and he admitted the only reason he filed it was trying to get him to remove this video. And they have a little quote from BitBoy here. They say that this other personality, Zach XBT, tweeted a bunch about supposedly BitBoy was working on direct scams, and then the thread that this Zach XBT guy does, that's kind of like an internet sleuthing thing, says that it has a flyer that what this image is supposed to be. I don't know whether it is, but this guy says that he basically posed as someone who had a project that he wanted BitBoy to promote, and he's claiming, this Zach XBT is claiming that he got this kind of like a flyer, they call it, or basically that people do this when they're influencers. They have little sheets or whatever that show their rates and what it costs to get them, and he's saying that this is what BitBoy gave me, and it does kind of look like one. It says that for a review he would charge $35,000, for a live stream mention $20,000, for a YouTube interview $40,000. For a Telegram in Bit Squad, because he's got a Bit Squad hosted by the cat, $10,000, and for a website article, $2,500. And it sort of cites some of the different demographics and what the thing is, and then this has what are supposed to be chats with BitBoy. And again, I don't know whether that's true, but that is what this person says happened. And then the Zach XBT says that BitBoy was telling him that he rigorously vets all the paid promotions, but then Zach XBT supposedly cataloged 7 crypto projects that BitBoy worked with, but then tried to delete evidence that he had shielded the projects because they had failed. There's a ton of cryptocurrencies that just sort of went into the dumpster, and a lot of people who were being paid to promote these, and so this is kind of the whole thread, and that's something you can go find online anyway. But that has. He's saying at least he put hashtag ad on the scam, right? And then just showing all these sort of deleted videos that he's alleging that there were rug pulls, and that that BitBoy was just sort of promoting stuff haphazardly, and then just kind of deleting things after the cryptocurrencies turned into disasters. So what is likely to actually happen at this hearing? And is BitBoy going to be hauled, or this way? That way. Is BitBoy going to be hauled away by the feds? And this is not actually a real photo of him. This is the best that an AI can currently do of BitBoy being hauled away by some kind of police officer. So it has not happened yet. It's not a real photo. And if you're worried about general AI taking over the world, there's at least some time between that, because it took me many, many iterations to get something even close to looking like BitBoy. But we're getting closer. So will this happen? What will happen with this? Really, I would say, first of all, in terms of whether there's any police on this, I think there will be against whoever, especially that email about paying in Bitcoin to like do something in people's families is very well over a line. It's couched as a warning, but like it seems a lot like a threat. And the FBI is probably going to track down whoever sent it and going to be like looking at all these calls and looking at everything. And so whoever did that is going to have issues in the long run. At this hearing, the judge, so there are multiple things the judge can do, and it's sort of hard to tell what they will do. Something that seems like a very big possibility is what's called a gag order. So a court can issue, when something like this is happening, where it's like literally causing threats to families and members of the court, a court could issue a gag order. A gag order says to a party to the case, or all parties to the case, like basically talking about this in public. You can only talk about this in court. Don't say anything else. BitBoy's attorney may come in and say, hey, I've quieted this guy down, or whatever. But the court, when you're looking at something like this, some of his posts are very much like urging real world action, even if it's protest or whatever. And it just, I think will probably strike a judge like it's gotten out of hand. And it certainly does to me seem like it's gotten out of hand what he's saying, even if, he says he's innocent and they're really, I haven't seen anything in either the complaint or in the things that they filed that is definitive proof that he was paid to endorse FTT. I will say that there's what I would call circumstantial evidence that suggests that he was taking endorsements for sure for other cryptocurrencies. But was he paid by Sam Bankman-Fried or have any relationship with him? There's really no proof of that would even get you to a jury right now. Doesn't mean it's not true. But it does mean that at least as of now, like I could not sit here and say that BitBoy did that for this particular cryptocurrency. And so the truth may end up being that BitBoy really, he touted other pump and dump things, but not this one, or other junk cryptocurrencies, but not this one. He certainly is very riled up about it, but it is something where the judge is going to want to clamp this down so that this is not turned into something where random crazy people on the internet are doing stuff. Even if it's not BitBoy, even if he had no involvement in them and never told them to do something like this, people can go take things the wrong way, or if they're real super fans of him, they might just do insane things. And so I would expect the judge to, at a minimum, tell him, be like, if you don't clamp down on this, you will get a gag order. Sometimes judges are reluctant to do the gag orders because it does kind of interfere a little bit with people's free speech. And there is there is a First Amendment. You do generally have a right to talk about stuff, but courts also can sort of craft orders like that when you are starting to get into people being incited into like real world violence, which is what's being talked about here. And certainly if you're the families of the lawyers, they're probably not happy about all this either. So who knows where the federal investigation will lead? Certainly will probably have some people facing some problems with this and maybe facing charges. And BitBoy, it's all just going to be whatever the truth is. So if he had nothing to do with FTT, had nothing to do with like being paid by FTX, then that when they get to discovery, that's going to come out. And what happens with the Binance lawsuit, that may be something different because it sounds like they have a little better proof of him being an affiliate of them over there. At least the stuff I'm seeing now, any lawsuit gets developed over time and may get better or worse as it goes. But we will see what the court says, and we'll do an update if something crazy happens at this court hearing or if we get more filings on it. So if you want to hear more videos about crypto lawsuits or just random celebrity lawsuits, definitely it's stuff that's important. Certainly if you're a crypto investor type person, knowing about the law and knowing about lawsuits is something that affects for sure the value of your investments, and you should know the law. It may seem like I'm getting into a super granular level of detail on this, but it may be worth subscribing to learn that granular level of detail, because I can promise you I've been on lawsuits where there are investors sitting in the back of the room trading by the moment based on what happens in our court hearing or our lawsuits and making money doing it. There are people who actually that's their full-time job, is just like trade based on what's happening in a trial. And for cryptocurrency, knowing what's happening with these bankruptcies and lawsuits is very important to avoiding some of this stuff, and maybe even to seeing which cryptocurrencies are going to go up, go down, whatever. And I just find it interesting, all the legal details and the crazy stuff you find in these. So hit subscribe and watch more videos wherever they're popping up on my little fade out screen.